Okay, hi guys, welcome back to another video with Pratham Test Prep. This is your host Sanjeet Bhatia again with a new video on your legal maxims and legal terms that might pop up in your CLAT or AILET examinations. Guys, if you are someone who's preparing for CLAT and AILET, you can definitely watch this video, and a like, share and subscribe would be great. Please don't forget to hit on the bell icon for our support also, so that we know that you are watching our videos very regularly. Okay, so if you are not a part of our Telegram channel, do make sure that you're subscribing to our Telegram channel for some free updates, and also you will find the material for last 2 years free of cost, which you can also go for the quizzes that are available on that channel, and also you can get all the material which is freely uploaded without any charges. So do go yourself and get yourself recognized on the Telegram channel, and also we provide all the free mock tests also on that group. So if you are looking for any of them, also you'll find them on our channel itself, right? So starting today's session. Okay, so there are a lot of terms and maxims I will be covering in today's session. So if you are watching this session, don't forget to watch it till the end, because there are going to be a lot of terms that we are going to discuss today in this small session that we are holding on YouTube today. So firstly, the term that is being used is called a fortiori. That means from the stronger, loosely, even more so, or when even stronger reason. Okay, so it is often used to lead from a less certain proposition to a more evidentary corollary, right? So that means that pehle jo kharab cheez thi ya less evident thi, usse certain proposition pe jana. Okay, so that is called, the term is called the a fortiori. So right, these are all Latin terms, so obviously they will have some funny pronunciation, so you don't need to learn all of them. You can just keep on looking at these videos and you will get through them, right? A possess ad esse, that means from being able to being, right? From possibility to actuality, jo hone wala tha wo ho gaya, right? So that is called a possesse ad esse. That means from being able to being, from possibility to actually, from being possible to being actual, right? So you can use that term also. Now the next term that is there for the day is a posteriori. That means from the latter, that is based on observation. ठीक है, that is empirical knowledge, that जो पहले से आ रही है, the reverse of a prior, used in mathematics and logic to denote something that is known after a proof has been carried out. ठीक है, in philosophy used to donate something that can be known from empirical experiences, जो पहले से experiences हैं हमारे पास, जैसे forest fires, weather, ये सारी चीजें ए पोस्टोरी है. दैट मींस फ्रॉम द लैटर विच इज बेस्ड ऑन द ऑब्जर्वेशन एंड द एम्पिरिकल नॉलेज. ठीक है जी, तो ये आपके 3 टर्म्स हो गई. कमिंग टू द नेक्स्ट टर्म फॉर द डे, दैट इज एंटे मॉर्टेम. दैट मींस बिफोर डेथ, दैट इज सी पोस्ट मॉर्टेम, दैट मींस आफ्टर डेथ. ठीक है, तो एंटी मॉर्टेम हो गया बिफोर डेथ, पोस्ट मॉर्टेम हो गया आफ्टर डेथ. तो नाउ coming to the next term for the day, that is apparatus criticus. That means critical apparatus, textual notes, or it can be readings relating to a document, especially in a scholar edition of a text. ठीक है जी, तो क्रिटिकल apparatus या कोई टेक्सचुअल नोट है जो कि रिलेटेड है, किसी रीडिंग है टू अ डॉक्यूमेंट, स्पेशली इन अ स्कॉलर एडिशन ऑफ अ टेक्स्ट, right? So that is called apparatus criticus. Now bona official, that means good services a nation's offer to mediate in dispute between two other nations, right? जब चाइना और इंडिया के बीच में डिस्प्यूट होता है, so a lot of times US tends to come in between China and India and take the dispute and also try to solve it, right? So that is the bona officio, that is the good services that a nation is offering to mediate a dispute between two parties also. Okay, now coming to the next term for the day, that is bona official. ठीक है, सेम कार्प डीएम, दैट मींस सीज द डे. ये आपने एक टर्म बहुत ज्यादा पोस्टर्स वगैरह पे भी देखा होगा. सो दिस इज द मीनिंग ऑफ द टर्म, दैट इज सीज द डे. ओके, केविएट लेक्टर, दैट मींस लेट द रीडर बी वेयर. when the writer does not vouch for the accuracy of the text. जैसे आप Wikipedia पढ़ते हैं, Wikipedia is not considered to be a page that you can quote in official citations. So definitely that is that the reader be aware. When you know that the document is editable, there can be some mistakes in the documents also, right? Probable a recent alteration of caveat emptor. Let the buyer be aware, or that you know the term caveat emptor is very, very famous. Now, caveat utilitar, let the user be aware, right? The user is responsible for checking the good suits his needs or not, right? अब एक कोई आदमी है, for example, he's buying a shampoo for anti-dandruff, right? But the shampoo is for making his hair soft, right? So then he has to be aware what are his exact needs in this case. So the user is responsible for checking whether the goods suit his needs or not. Okay, so that is what is the meaning of caveat utilitar. Now coming to the next term for the day, that is de lege lata. That means from law passed or by law in force. Okay, so any law that is in force, right? IPC, NDPS, whatever. So from the law that is passed or by the law in force, when the punishment is given, it's called de lege lata. Now the next term is de omnibus debitabidum, right? Debi ten dum, right? So that is the real term that is being used here. Be suspicious of everything, doubt everything, right? So that is the meaning of this term. So Karl Marx's favorite motto is being used here, which he says that critique everything in a capitalist economy, right? So that is what the Karl Marx is, a very famous philosopher and also a sociologist. So when you'll go into your law school also, you'll read a lot about Karl Marx and also his theories and the readings that he has written. So definitely it's very interesting to know. So that's what the meaning of the term is being interpreted as, critique everything in a capitalist economy. So I hope you have understood and you are able to understand this term also. The next term is erratum. That means error or any mistake that is being caused. So that is called erratum. List of errors in a previous edition of a work are often marked with the plural, that is called errata. That is called errors. Okay, so erratum means error, and errata means errors, right? So that is the difference in the Latin here. So when you read any book or you buy a new edition, there is always a list of errors that were there in their previous editions that they try to reconcile in these ones and try to correct them also. And so they mention it under the category of erratum or erratas. That means errors that are there. Okay. Now coming to the next term for the day, that is ex hypothesis. That means from the hypothesis. That means thus by hypothesis. Anything that is hypothetically assumed, right? From the hypothesis, that means जब आप एक एजुकेशनल इंस्टीट्यूशन में पढ़ते हो तो वहां पे ऑब्वियसली आपको प्रोजेक्ट्स दिए जाते हैं, तो उसके अंदर आपको एक हाइपोथेसिस चूज करनी पड़ती है दैट कि यस दिस इज द सिनेरियो दैट आई एम कंसीडरिंग ऑन व्हिच आई विल बी रिसर्चिंग ऑन माय प्रोजेक्ट. सो दैट इज कॉल्ड एन हाइपोथेसिस. सो द हेक्स hypothesis means that from the hypothesis, thus by hypothesis. Okay, now the next term is ex lege. That means from the law, right? Anything that is coming from the law is called ex lege. Coming to the next term, that is ex libris. That means from the books. Anything that is coming from the books precedes a person's name with the meaning from the library of, right? So anything that is coming from the books is called ex libris. Okay, तो library से आप याद करें, books होती है library में, तो it is coming from the books is called ex libris. So this is the term that is used in Latin for that. Now next is ex post. Ex post facto is different. Ex post is different. From, after, or afterwards is the meaning of ex post, right? After the event, based on the knowledge of the past, measure of the past performance, any of these terms can be used here, which is called ex post. Now ex post facto means from a thing done afterwards. Okay, so when a said of a law with a retroactive effect, that means when the effect is going in the past and also coming to power, right? For example, Hindu Succession Act के अंदर right now women were given right in their father's property as the son was being given that right. Okay, so equal rights दे दिए गए थे women को property के अंदर. तो उस law को कोर्ट ने बोला था that this law will be applicable ex post facto. That means they will have a retroactive effect. That means अगर किसी के फादर 2005 में मरे जबकि लॉ 2019 में आ रहा है, तब भी उस लड़की का उसके फादर की प्रॉपर्टी में फुल अधिकार होगा, राइट? सो दैट इज व्हाट इज द मीनिंग ऑफ एक्स पोस्ट फैक्टो लॉ. दैट मींस देयर इज अ रेट्रोएक्टिव इफेक्ट ऑन द law here itself, right? Coming to the next term for the day, that is gratia verces naturae. That means through God's mercy and nature, right? So any truth that comes through God's mercy and nature is called gravita versus naturae. That it's not a very well known term also, so definitely it might pop up in your exam, but there are very less chances of that. Now the next is hic et nunc. That means here and now. So next is ibidem. Now ibidem is in the same place. It is usually used in bibliographical citations. Okay, कि last source of previously referenced कहाँ पे है, ठीक है? तो in the same place is used ibidem. That is what is being told here in this term itself. Now it is also called ibid, or it is also used ibidem, right? Coming to the next term for the day, that is idem quo. That means the same as, not confused with an intelligent question. Okay, the same as, the meaning of the term is the same as. And what do you mean by that? Not to be confused with an intelligent question. Okay, now in act 2 means in act. Okay, so in the very act or in reality, जब कोई आदमी मर्डर करके आया बाहर तो उसको बोलेंगे in act 2. That in the very act, he was caught while he was murdering that person, so he was caught in act. So it's called that the person was called in act 2. Okay, now the next is in loco parentis. That means in the place of parents, a legal term which is assuming parental custodial responsibilities and authority. Okay, जो जब बच्चा स्कूल जाता है, कोई भी बच्चा स्कूल जाता है, तो टीचर उसका लोकल गार्जियन बन जाता है उस टाइम के लिए, एंड दे आर टिपिकली बाउंड बाय द लॉ टू एक्ट इन लोको पेरेंटिस इन द प्लेस ऑफ पेरेंट्स. लाइक द चिल्ड्रन आर सेंट टू द स्कूल एंड द टीचर हैज टू एक्ट इन लोको पेरेंटिस. दैट मींस इन द प्लेस ऑफ parents, because she has the custodial responsibilities of the students who are studying in her class, right? Now coming to the next term for the day, that is ab initio, right? So now ab initio means from the beginning or inception. जो चीज शुरू से या पीछे से आ रही है, राइट? सो अब आप कई बार होता है ये आपको टर्म कॉन्ट्रैक्ट लॉ के अंदर सबसे ज्यादा सुनने को मिलेगी, दैट द कॉन्ट्रैक्ट वाज void ab initio, right? That from the beginning itself the contract was void, right? From the first act itself it is being declared void. That means it is not a valid contract, right? So ab initio is the term that you will hear in contracts itself under the meaning of void ab initio. Now coming to the next term for the day, that is actus curare neminem gravitia. That means an act of the court shall prejudice no man. Okay, so an act of the court should prejudice no man, मतलब कोई किसी कोर्ट को किसी भी आदमी के साथ prejudice नहीं करनी है. That is the meaning of actus curare nemin grabevit, right? So that is the meaning of this term itself. Coming to the next term, that is actio personalis mortuario cum persona. That means a personal right of action dies with the person. अगर किसी इंसान पे मर्डर का केस चल रहा है और वो इंसान खुद मर जाता है, तो राइट ऑफ टू एक्शन है उस पर्सन के ऊपर, वो मर चुका है उस पर्सन के साथ ही, राइट? सो द पर्सनल राइट ऑफ एक्शन डाइज विद द पर्सन इटसेल्फ, राइट? सो दैट इज द मीनिंग ऑफ द टर्म बीइंग यूज्ड हियर. Now the next one is audi ultram partem. That means listening to the other side, right? Let the other side be held as well. Okay, तो आप जब कोर्ट रूम जाएंगे तो कोई भी कोर्ट रूम में बिना दोनों पार्टीज के आर्ग्यू किए हुए कोई भी डिसीजन नहीं दिया जाता, कभी कभी दे दिया जाता है, ऑडी अल्ट्रम पार्टम नहीं सुना जाता, कई बार केसेस ऐसे भी टाइम होते हैं, बट मोस्टली दे लेट द अदर साइड बी हर्ड एज वेल. इट इज द राइट ऑफ द अदर साइड टू प्रेजेंट इट्स ओन केस and provide any explanations that are required for the court to hear in that particular case itself, right? So it is called audi alteram partem. Now the next is consensus ad idem. That means when the two parties to an agreement both have the same understanding of the terms and agreements. Okay, so these are some of the essentials of a valid contract. So for example, consensus ad idem क्या हो सकता है कि आप किसी से सैंट्रो खरीदने गए, ठीक है, और उस इंसान के पास दो सैंट्रो गाड़ियां हैं, एक रेड कलर की और एक व्हाइट कलर की. आप व्हाइट वाली गाड़ी खरीदना चाहते हो और वो इंसान रेड कलर की गाड़ी बेचना चाहता है. तो आपका जो अंडरस्टैंडिंग है, जो टर्म्स और कंडीशंस की अग्रीमेंट की, वो आप नहीं समझे हो, तो देयर इज नो कंसेंसस एट इडम. सो देयर हैज टू बी a mutual understanding of the terms and conditions, that both of you are thinking about the same goods, same price, whatever is it, and both the parties are understanding the terms and conditions of the contract itself, right? So that is what is being done here. Now coming to the next part is ignorantia juris, ignorance of law. Ignorantia juris non exusta is the other term that is being used. Then it is, the meaning of that term is ignorance of law cannot be an excuse, right? Ignorance of law cannot be excused. अगर आपने ये केस पढ़ा होगा, दुबई से सोने की बार लाने वाले लोग पकड़े जाते हैं, right? So that is what they say, that we were not aware that in the country that there is a law that we can only carry 500 grams or whatever. So the ignorance of law is not an excuse. So that cannot be called as an exception to the law. So you will be punished if you are ignoring the law itself, right? Coming to the next term for the day, that is pre-curiam. That means in the opinion of the court. If there is anything that is in the opinion of the court, it is called pre-curiam. Okay, so the court can give any opinion on any laws or any constitutional readings, and they can present their view and they can write it as per curiam, okay, in the opinion. Now abscond means escape from custody or avoid arrest. ये आपने term newspaper में बहुत बार सुनी होगी, that there are absconding individuals, financial crimes they have committed and they are absconding. That means they are escaping from custody or they are avoiding arrest. इसके लिए एक और हिंदी में टर्म, या हम बोल सकते हैं कि ऐसे एक लिंगो में टर्म यूज किया जाता है, दैट इज कॉल्ड अंडरग्राउंड होना, राइट? सो दैट इज व्हाट वी हैव हर्ड. सो हियर इट इज कॉल्ड एब्सकॉन्डिंग. इन द रियल लीगल टर्म फॉर दैट इज कॉल्ड एब्सकॉन्डिंग, व्हिच इज एस्केप फ्रॉम द कस्टडी. ओके, कमिंग फ्रॉम द नेक्स्ट इज एडवर्स पोजेशन. सो नाउ द doctrine of adverse possession is defined under Article 65 of the Limitation Act, which specify about the time period of 12 years up to which the claim of title of immovable property is applicable. अगर मैं 12 साल किसी प्रॉपर्टी के ऊपर रहता हूं और कोई मेरा पोजेशन लेने नहीं आता, तो मैं क्लेम कर सकता हूं एडवर्स पोजेशन उस जगह पे. बट द कोर्ट काउंट ऑफ 12 years starts when the possession of the defendant becomes adverse to the plaintiff. अगर कोई मेरे पे केस नहीं करता 12 साल 15 साल तक, और मैं जाके उसको रजिस्टर करा लेता हूं और कोई प्लेंटिफ नहीं आ रहा, कोई मेरे पे क्लेम नहीं कर रहा, तो जगह पे मेरा एडवर्स पोजेशन हो जाएगा. फॉर इंस्टेंस हियर ए who is the owner of the land gives this property for maintenance to B, and after 12 years if he comes back to reclaim the property, the court will not entertain his suit in his favor. ठीक है जी. अगर आपने मेंटेन करने दिया और आप 12 साल तक कभी देखे ही नहीं कि क्या हो रहा है वहां पे, एंड यू नेवर केयर्ड, एंड द पर्सन स्टार्टेड लिविंग देयर, मेड हिज ओन हाउस, and then you go and you reclaim and you want to reclaim the property after 12 years, that's not possible. The person can claim adverse possession on that because the plaintiff was completely unaware about the condition of that place. Okay, so that is something that you should know, and it is very interesting to know all these things also. Now caveat emptor and caveat venditor. अभी हमने पीछे caveat utilitor पढ़ा, ठीक है, ऐसी टर्म्स पढ़ी. अब एक और ये इस तरीके की टर्म है, caveat emptor means the let the buyer be aware and caveat venditor means let the seller be aware. अब एक कोई बायर है, अगर वो कोई भी प्रोडक्ट खरीद रहा है तो ऑब्वियसली ही शुड चेक द एमआरपी दैट इज बीइंग चार्ज द एमआरपी और नॉट, और देयर इज एनी अदर expense on which the seller is just making it. Okay, so that's what he has to check. So the buyer has to be aware. He only has to pay what is the MRP of that product. Now the seller be aware. Now the seller can be aware. Now the seller has to make sure that he's not selling the expired goods to anyone, or he's not selling anything which has hazardous in nature. So the seller has to be aware in such a case too, right? So that is what is the term that is being used, is called caveat emptor and caveat venditor. Coming to the next part, that is cognizance. When there is a judicial notice of an offense that the judge has taken a notice of the offense, magistrate के सामने होता है, and the magistrate takes the cognizance of the offense. That means he is registering or making a judicial notice of that offense, right? The word cognizance is being used in the court to indicate to the point of time when the judge or the magistrate for the first time takes judicial notice of an offense. ठीक है जी, जब वो पहली बार judicial notice लिखते हैं उस offense का, तब उसको cognizance कहा जाता है, right? So that is what is the term that is being used here, is defined in such a manner. Now coming to the next term, that is exchequer. Exchequer is defined as the royal or the national treasury, or is also defined as account in which the tax fund and other public funds are deposited. तो जितना पैसा यहाँ पे बचता है हमारे टैक्सेस वगैरह से, वो सब एक्सचेकर में भी डिपॉजिट होता है. So exchequer is the national treasury and which is defined as the account into which the tax funds or any other public funds are deposited. ठीक है जी. So that is also there. Now the next term is fiduciary relationship. A doctor and patient, a lawyer and a client, all these relationships are called fiduciary relationship because these relationships are based on the sole motive of trust itself. So that is called fiduciary relationship. Now some of legal terms is forbearance, an international delay in collection of a debt or demanding performance on a contract, usually for a specific period of time, is called forbearance, right? Now the next is defraud. That means to deceive, falsehood, like anything tricking, जो भी आप deceiving activity करते हैं उसको कहते हैं defraud. Now chattel, that means a term that is being used for personal property which is movable in nature, right? Which is distinguished from the real property, land and improvements, that can be any roof, sheds, anything, right? So that is called chattel. Now coming to the next is quid pro quo. That means something for something. We have studied this in our previous videos also. Next is guarantor, a person or entity who agrees to pay, right, or another's debt under a contract if he fails to perform or pay. ठीक है जी, जो गारंटी लेते हैं लोग बीच में पेमेंट की, they are called the guarantors, right? So incidental beneficiary is a person who obtains a benefit as the result of the main purpose of trust, right? So that is called incidental beneficiary. ठीक है? So that is what is being the term being used. Next is a temporary injunction, मतलब कोई stoppage लगा दिया गया, prohibition लगा दिया गया, any action by a party to a lawsuit until there has been a trial or any other court action, right? तो कई बार बोलते हैं ना stay लग गया property पे या कुछ भी किसी भी जगह पे, तो वो stay लगाने को temporary injunction किया जाता है, stay हट भी जाता है. So that is a court order prohibiting any action by a party to a lawsuit until there is a trial. Okay. Next is syntheter. That means Latin for having knowledge. In criminal law it refers to knowledge by a defendant. ठीक है जी, तो knowledge को कहते हैं syntheter. Now easement, the right to use the real property of another for a specific purpose. Okay, so when there is a right to use any real property of another for a specific purpose is called easement. So it is called an easement right. आपने इसके बारे में काफी सुना होगा. So the right to use the real property of another for a specific purpose is called easement rights. Coming to the next part, that is it for today, guys. I hope you were able to get some knowledge about these legal terms and legal maxims. And I have discussed a lot of legal terms and legal maxims today. So do make sure that you are making a note of all of them and you are trying to learn all of these legal maxims. Okay. As you all know that we will be taking a value added session on Friday. So do join us live from 3 to 4 on Friday itself also. And also do take care of yourself. Use your mask and hand sanitizers, and also make sure that you are washing your hands regularly, and do take care of yourself and maintain social distancing. Bye bye, guys. Have a nice day and keep preparing.